Now we're going to talk about, again, some more criminal liability. Last time we were talking about criminal liability. We wound up talking about the model business code and the malice distinction, two kind of malices, which are pretty much, in terms of discussion of these matters, taking the place of the old distinction between mens rea crimes and specific intent. Yet there's still a room for both of those, in that statutes may mention things that bring up specific intent. But what we're going to talk about today picks up from there, criminal liability. So last thing I think we mentioned was burden of proof. Of course, you all know that that's beyond a reasonable doubt in a criminal trial. I think the one that people don't realize is the one that's in civil trials, which is a preponderance of the evidence. So corporate criminal liability is a different kind of thing. It goes back, I think, to the old Roman law of master and servant. The servant became responsible for anything the master became responsible for anything the servant did. And so the master would frequently punish severely a servant who got him into trouble. And and would also, however, defend him as a point of honor. And I think this has some effect today, although I find corporations are not really being, the corporations, the owners, are not really the masters. It seems like the agents and their employees. And so you'll find that if a corporate officer is being prosecuted, the corporation will usually pay for his defense and try to help him out as much as can, even withhold what evidence they can from the prosecutors. However, the prosecutors have tools with which to make them disclose information. So, corporate criminal liability. An officer, agent, or an employee under their control violates a criminal statute while acting within the scope of employment. That could create corporate criminal liability, so the corporation itself may be made to pay. That's the way our laws read. Some of them are directed to corporations. Some are directed towards the agents, that's the officers and employees. Corporation fails to perform specific duty imposed by a regulation or statute. So every corporation will have a compliance officer. You need that also if you're talking about a partnership. You need to have somebody making sure that the firm is complying with what laws there are. And there are people who specialize in that area. Obviously, they're employed by the big corporations. If you're just a small business, maybe just a restaurant with an owner and he has people working under him, maybe he's got a couple partners, you don't have maybe somebody who is devoted to simply compliance, but somebody would basically be in charge of that. And so that's the way it works with these smaller businesses. They oftentimes have to wear more than one hat. Corporations fail to perform specific duty imposed by regulation or statute. So this is, I think, one of the reasons why regulations and legislation is so much often opposed by businessmen, because they have it imposed as a duty, and it can result in them being held criminally responsible. Usually that just simply has been, for the most part, that has usually just been a matter of being fined if they were found guilty. And there is also a certain reluctance to go after white-collar criminals. You sometimes hear a lot said about in the press, and they appoint commissions and they do things. I don't know if they really pursue it very hard, though. Crime was authorized, requested, or another result. Now, these are things that will result in corporate criminal liabilities. Corporation fails to perform a duty. An officer, agent, or employee under control violates criminal statute. Or maybe the crime was authorized by that agent, that managerial agent. If the crime was authorized, requested, commanded, committed, or tolerated by a high managerial agent. Does the high managerial agent know that a crime is being committed? He can't just sit there and say, "Well, I'm not responsible for that. I didn't do that." And so, but you'll find in scandals that oftentimes they'll pick somebody out to be the fall guy. In Enron's case, they had decided that Andy Fastow, as chief financial officer, should be held accountable for it, and they said, well, it's all Andy Fastow's fault. They had given him unlimited power and had basically praised him a lot as being very innovative. They needed to look into his innovations. His innovations were simply cooking the books. Corporate criminal liability of officers and directors. So besides the corporation itself being made to pay fines, what else can a corporation do? You can't put a corporation in jail, right? You can take its money. You can close it down. That's about it. Who are you hurting? Well, you're hurting the owners to some extent, but you're also hurting the customers and the employees, oftentimes very, especially the low-level employees who are not necessarily responsible for any sort of crimes. Although sometimes they do know that things are going on, and they could be very helpful sometimes if they would, turn in their boss, or turn in the corporation. But they worry about that. And as a matter of fact, they will ostracize an employee, a fellow employee, who turns evidence over or brings the authorities in on something because they see that as a threat to their livelihood, to their jobs. And so he'll be treated with a good deal of skepticism. Whistleblowers, we like to think that they are our heroes, and in a sense they are our heroes, but they don't get much respect in the workplace from their fellow employees or the managers who they work for. So these are ways in which the corporation becomes liable. In corporate criminal liability of officer directors, they're liable for their own acts regardless of whether done for their own benefit or the benefit of the corporation. So an officer might be tempted to say, well, I did it because the corporation needed something like that, or I needed to do this because of the corporation. You can't commit a crime to save the corporation, or you can't commit a crime to save money or make money for the shareholders. That's no excuse. It doesn't matter that it doesn't benefit him directly. It still benefits him, right? In terms of he's considered to be a better manager if things go well financially for them. And of course, he won't be considered very well if, in fact, there are criminal charges brought. So, in some cases, a director will be, an officer might be sent to prison, get out, in a few years he's working in a similar position in some other firm somewhere. So they seem to be not quite as tainted as lower level street criminals. And street criminals is a broad category, so we can put in that category those people who are picked up on drug charges. And they're their own worst enemies, but they're being put away and criminalized and basically prevented from really having any sort of career. Liable for crimes committed by those under the supervision of an officer or director. So if he's in charge of somebody, you get this. Say you're in an accounting partnership. Usually there are people who work under the partners, the associates that work under them. He's responsible for them, so he has to know what they're doing. He has to make sure what they're doing is legit, that they are complying with requirements, and that they're doing their job right. They're not being negligent. They're not being careless. They're not being bought off. They're not being doing something that's going to eventually harm the firm in a very serious way. And when you see a scandal, that just isn't what's been going on then. Usually it's oftentimes a scandal because the officers and agent directors and officers have allowed the employees under them to do things that they wouldn't have. And basically will oftentimes claim that they didn't know that it was going on. Or I think like Jeff Skilling said, well, I'm not an accountant. Ken Lay said, I'm not a fool, but I got fooled. Even though you're not an accountant, if you're supervising accountants, you have to know what their work product should be like, what their responsibilities are, and what they need to be producing in terms of work. You ought to be able to read their financial statements and know when you're being led astray. You can't just allow yourself to be a fool and take that money and then claim you're not responsible because somebody else did it, you're going to ultimately bear responsibility. And the Sarbanes-Oxley Act added to that to some degree. Thompson Memo controversy. The Department of Justice has aggressively prosecuted high corporate agents in the early years of the 21st century. Okay, so before that, they were more deferential to corporate agents and officers, with the idea was that these are respectable men and we don't have to treat them like street criminals. And so they were oftentimes very deferential. There's some of that deference. I wouldn't say that they're not still, I wouldn't say they had became totally, indifferent to the fact that they're dealing with a respected man of the community, a man who may be actually even leading charitable organizations or contributing to charitable organizations, having a man who maybe has good reputation in the community for all the good works that he does. That's fine and good, but this is really no license to then commit crimes, is it? So under the Thompson Memo, they expect corporations to deny corporate officers corporate funding for defense. So this was very typical for corporations to do this. Now, you wouldn't find a corporation doing that if one of their very low-level employees had committed some street crime. They wouldn't be involved with that. But at a higher level, with securities scandals and scandals involving the money of the corporation, they may actually defend it, because the officer is seen usually by them as perhaps maybe working for the best interest of the corporation by violating that statute. So it's sort of condoning it. So under the Thompson Memo, they would expect corporations to deny corporate officers funding for their defense. So the corporation should be paying for their defense. The officer should be paying for his defense. Offending corporations may be deemed non-cooperative and incur higher risk of prosecutions. So that's what the memo says. If you're going to fund these people, we're going to presume that you are non-cooperative. So you need to cooperate with us. We're going to be wanting to look at some papers. If you're making us always go in and get subpoenas, making it difficult, you're trying to claim all kinds of privileges. And they can, right? Because the corporation is a person. So on behalf of the corporate person, the officers and directors can claim privileges for the corporation, which may actually benefit them and people who work under them in ways that it maybe shouldn't. It's never meant to. Deferral of prosecution. Cooperating corporation. Now, one of the reasons why, if you were on the board of directors or if you were an officer of the firm, you would want to cooperate is because there's something called deferral of prosecution. Cooperating corporations are offered by the DOJ an agreement. The DOJ, the Department of Justice, that is, promises not to prosecute the corporation. So we're talking about they promise not to maybe prosecute the corporation if they fully cooperate and refrain from further criminal conduct. So they have to. This is sort of the same deal you find where you have criminals who are operating together in a criminal enterprise. You get one of the criminal, if he's cooperating, will get certain concessions, and maybe they won't prosecute him. In this case, it's the corporation itself. I don't think the DOJ really wants to prosecute corporations. Like I said, what good does it do to take money out of a corporation? It's simply you're denying money to the shareholders. To some extent, they take that risk by turning it over, which should maybe cause them to be more careful who they're investing in, and maybe more carefully watch them. But I don't think it really does nowadays. Nowadays, people don't invest so much in a corporation as they invest in the market. But the deferral of prosecution is something that happens, and it's pretty much like that. And corporations are not being treated like street criminals, certainly, and officers are not being treated like street criminals. They're treated with a certain degree of deference, but not maybe as much as they were at one time under this Thompson Memo. Deferral of prosecution, so that's what that was about. The plea bargain agreement. an accused may be offered a reduced sentence. So if they are prosecuting an officer or a director rather than prosecuting a corporation, then we can talk about a plea bargain. Andy Fastow had a plea bargain with the securities agents, and the deal was that he would agree to plead guilty and get they would recommend a 10-year sentence for him rather than a higher sentence. So you look, Andy Fastow, who was at the center of the controversy, and according to the others, he was responsible for it all. That was not the way the jury came to look at it after they heard the testimony of all the people, including Andy Fastow and Jeff Skilling and Ken Lay and the chief accounting officer. Also, once they heard all these people speak, they decided that it was a conspiracy in some sense, although that's not, I think, the main charge. Anyway, the plea bargain agreement, an accused may be offered a reduced sentence, parole, or other considerations. Now, Andy Fastow got 10 years with his plea bargain. He also got a reduced sentence for his wife, who got involved with it somewhat also. She was given a 1-year sentence, and but she was obviously less guilty, and so there was also an agreement that they would not both be in jail at the same time, so one of them would be home with the children. And probably he didn't serve 10 years. Probably served maybe 2/3 of that at most, maybe less. And take Ken Lowe didn't do anything because he died before his last appeal, so the thing was not decided. I mean, it was not a final judgment because he still had the opportunity to appeal when he died. But Jeff Skilling got sentenced to 25 years as opposed to 10 years for Andy Fastow. Jeff Skilling would have to probably think about that and wonder why he didn't cop a plea too. Anyway, often the accused will be required to testify against other suspects. That's typically what they're going to have to do, where there's some sort of conspiracy or some sort of team effort where there's a group of individuals who are cooperating to commit a crime. They're going to have to cooperate with the police, perhaps to get a lower sentence. If they want a lower sentence, they're going to have to then, tell what they know, and the police have to believe them. They have to believe that they're going to tell the truth. They want the truth, and they want them to tell the whole truth about themselves, and they have to actually admit their guilt. Testify against other suspects who participated, directed, or conspired with the accused. The accused may also be required to make restitution to the victims of the crime. So that could all be in the plea bargain agreement. Because in prosecuting a crime, unlike the tort case, there's not really necessarily a concern on the part of the prosecutors or even the judge. Maybe there might be with certain juror members, but even they are not really directed to do that. The idea was that these people have done a crime and that they should be made an example of, if you would. They should be punished, and so we don't want people doing that, so we punish them, so it offends society in general. And so it becomes less an issue of compensation, but that can go to mitigating sentences, and it can be part of a plea bargain agreement. So the prosecutor, it's not right to say he's not at all concerned about the victims. He is, and I suppose in the plea bargain he could maybe get certain provisions for them. He can require them, if they've got some money squirreled away, they haven't just spent it all on booze and women, then they can pay something, right? And so the accused may also be required to make restitution. Restitution is to restore the victims to their estate. With corporate crime, if shareholders have lost money, we might be talking about a lot of money, and it's also a question about how do you calculate how much they lost. Is some of this something that would have happened anyway? Would the corporate stock have gone down anyway? Or was it all a matter of time? Or is this corporate criminal responsible for the magical thinking of investors who perhaps are not paying attention or being gullible, and they're listening to these talking heads on TV that telling them, oh yeah, Enron's going down right now, but it's going to be back up. We don't think there's anything in these charges. Anyway, so that's another issue. Okay. Characteristics of corporate crime. You have the corporate entity. It's going to, if we're prosecuting the corporate entity, it's going to be liable only for monetary penalties. So we said that. There's a public relations issue. So a corporation may, for a crime or any other kind of wrong, for tort that matter, may actually be driven out of business. May not have people who want to use it. In some sense, it happened to Arthur Andersen. Although there is an Arthur Andersen, I believe, operating overseas. But in this country, they're pretty well, the people who work there all needed to go find new jobs. And so that's not a very pleasant prospect. Right? And these were the people who actually still owned it, I mean, in a sense, or primarily owned the Arthur Andersen. Prosecutors will bargain with the entity to capture the agents. So, if you're a director on there, you want to save the corporation. And so that may mean that you need to be very cooperative with the prosecutors, the federal prosecutors. And I'm talking federal prosecutors because effectively there are very few states that have a program enforcing corporate, laws in terms of securities and high crimes that are committed. It's pretty much nowadays something that the feds do. And yes, New York, they do it in New York, but New York is where Wall Street is, and New York Fed's very famous, and so it's a center of financial activity. So the New York State is actively involved, but that's the only one I think that really does much. There are others occasionally they might do something. Anyway, liable for monetary penalties only. Prosecutors will bargain with the entity to capture the agents. They're not, really, like I said, they're really not interested in going after corporation. What can they collect? They can collect money for the state. Maybe they can, maybe the judge will require corporations to pay money to the victims. But oftentimes there isn't any money to pay. If they've been defrauding shareholders, it's because they haven't got the money that they want the shareholders to believe they have. And the shareholders then bid up the stocks thinking that there's more money there than there is. And then it's too late, they find out that there was never any money all along. So, Enron money didn't suddenly disappear. It had not really been there. The corporation had not reached its earnings targets for years, but it lied about it for years. Its officers, Jeff Skilling and Andy Fastow and Ken Lay and the chief accounting officer all lied repeatedly in meetings with shareholders and people who advise shareholders. At shareholder meetings, they would mislead them, and they allowed the books to be cooked. And they should know better. Anyway, the corporate entity also is, if monetary penalties threaten to injure a corporation, then a judge will often reduce or deny them. So if you prosecute the corporation, the judge has to consider, do I want to hurt this corporation so bad that it goes out of business and all the employees are then out of work? So my dad worked for a steel company that was actually hurt not by prosecution, not by a tort, but the labor unions, the steel workers, went on strike to get the union scale, which is the amount that the union says that all steel workers should be paid. This old steel plant was really, they claimed that it was not able, the claim of management was they weren't able to pay those kind of wages. And so the headquarters, not where my dad worked, he worked at the local plant. People at the local plant didn't make this decision. At the headquarters in Chicago, rather than in Cincinnati where Dad worked, or across the river in Newport, Kentucky, they made the decision to close the plant. And so that same thing can happen with a scandal like Enron. And it did happen with a number of firms in 2002, which were in similar shape to Enron. So prosecutors will be bargaining with the entity to capture the agents. If the monetary penalty threatens to injure the corporation, the judge will maybe lighten up on the corporation, will not put as stiff a penalty on it, if that will help save the corporation. In Enron's case, it wouldn't have made any difference. The shareholders had already decided they were, I mean, basically, they were selling their shares, and So since all of them were selling, the stock plummeted, and it wasn't worth anything. It was worth 14 cents, and it had been worth hundreds of dollars before that, $125, $150 a share. Then now it's worth 14 cents. You can imagine if you had your pension tied up in that, and which unfortunately a lot of people who worked at Enron did have their pensions tied up in that. Not a good idea to put your pension money in the corporation that you work for. You need to diversify. That's not diversification. Anyway, agents. What about going after the officers and directors? Those are the agents. After the financial statement scandals, after the financial scandals of 2001, officers and directors have been increasingly indicted and convicted. So there were a lot of indictments in 2002, and convictions followed. And there was just a tremendous number of them that were prosecuted. I think at Enron alone there might have been 100 people who were actually prosecuted. And so multiply that by about, 10, 20 other firms that were in serious trouble. You got a lot of people maybe being prosecuted at these other firms too. It was so big that Congress had to make a special task force to handle the prosecutions. And even then they couldn't handle all the prosecutions that they could have handled. Or, there were a lot of people who weren't charged because they just didn't have enough people to charge them. They usually were the smaller fish, like Andy Fastow's wife, who probably would not have been charged except by charging her. They had more leverage with Andy to get him to cop a plea, right? So superiors can be indicted for actions of their employees. Remember, we said that before. For employees they control. So if you are in control of a person, you could wind up being indicted if he's doing things that are wrong. So don't turn the other, don't turn away. Don't turn the other way when he's doing something funny. If it's something that strikes you as odd, look into it and find out what it is, and don't be too quick to accept his explanation if it doesn't make any sense to you, or others might think it doesn't make any sense. If others doesn't make any sense, why is it making sense to you? Because he's working for you, you don't want that's wishful thinking on your part. CEO and CFO under SOX 906 now have to sign certifications that they have actually very carefully looked at the books, looked at the accountant's work, and they sign off on the accountant's work, saying that we have looked at these and they are prepared well. And so this goes against the idea that Ken was saying, well, he was an accountant, therefore he couldn't really judge what the accountants were doing, that he had relied upon Arthur Andersen, and that he relied upon the other accountants to do that. He was a businessman. He has to understand accounting as well. If he's going to occupy the top spot, he's got to understand what these other people are doing. You can't lead somebody, you can't be in charge of somebody that you don't know what he's doing. You've got to be hands-on. Superiors can be indicted. So CFO, CEOs under SOX 906, that's the statute, in section 906 of the Sarbanes-Oxley Act, they have to sign these certificates, which can then be held against them. Well, you knew you were supposed to do that. In other words, he can't claim, well, I can't read these. I couldn't see that his financial statements were full of holes. Other people did see it, and some people made a lot of money from seeing it, and outside firms, and it had been pointed up to them in meetings that had been challenged. Jeff Skilling and Kim Lay basically would deny it, and Bethany McLean, who wrote a fine article about Enron in Fortune magazine, was called. They said that she didn't know what she was talking about. She just wasn't up. But she did know what she was talking about. She was right, and what they were denying was wrong. And it was wrong for them to be denying it. They needed to take her more seriously. She was a quant, and she knew exactly what she was doing. Okay, Securities Act, Section 24, makes it criminal for anyone to willfully materially lie in a filed registration statement. It makes it a criminal for a person to omit a material fact. You know what a material fact is? It's one that's going to make a difference. Maybe it makes a difference between $1,000 and $100,000. So, if there are wrong entries, if there are things that are been, in Enron's case, you had things that were written up, included as profits, which had never been received and never did get received. So they were counting profits that they'd never make on this markup accounting, which was inappropriate for their firm. It was something that trading firms do. They tried to claim they were a trading firm, but they were an oil and gas firm. That's what they were, and not a very good one. They were very, very awful to their clients. They were really practically destroyed the California energy market. People probably died in hospitals because of them. So omit a material fact necessary to avoid making misleading statements in the filed registration sign. So they got to be forthcoming. They got to tell what they know. They can't withhold information. You know, they can't allow the accountants to withhold information. They can't do what was very typical of some of these CEOs of the period. The CFO would come in and he'd have the reports, the financial reports, and he'd hand it to him. And the CEO would look at it and say, it's not acceptable. We're not reaching our target. Go back and do it again. And when you come back again with some adjustments, they would never be enough until they hit the target. So, you know, it's sort of like what the CFO, I guess, should have done was asked him, well, what number would you like to see on there? Well, I think he already knew that. But, you know, many of them would testify that the CEOs were actually not accepting an honest appraisal of the condition of the firm. And so that's why it led them to do what Andy Fastow did, which was to give a dishonest appraisal of the firm. Willfully violates any other provision of the federal securities law. So this is Security Act, this is federal law. Like I said, most of these wind up being prosecuted in federal courts. CE Section Securities Act of 1934. You remember 1934? That was under the Roosevelt administration when we had a lot of scandals back when Roosevelt came into office. There were lots of scandals from the previous administrations held over from the Hoover administration. You know, there were a lot of firms that got into trouble, and there were these prosecutions. And so any person, this act says that any person who knowingly and willfully makes or causes to be made any false or misleading statements in any application, report, or other document required to be filed with the SEC commits a criminal act. So these are these Roosevelt administration, these New Deal regulations, legislation, were really what the Enron employees pretty much got prosecuted under. Yes, there had been amendments to them over the years, but not substantially like the Sarbanes-Oxley Act. Sarbanes-Oxley Act moved it up a notch. It made the penalties higher. Well, how much higher do you need to go? Like I said, Jeff Skilling got sentenced to 25 years, and he wasn't the only one. Olin of a competing firm in the energy field got 23 years. And Jeff, I'm sure Ken Lay would have gotten at least 20. And with a plea bargain, the best that Andy could do was just get 10 years. And that was pretty good. Considering how he was so intimately involved with the scandal, you know. And I think, you know, the clumsy attempt by the chairman of the board and the CEO, by Ken Lay and Jeff Skilling, to put it all on Andy, actually I think worked against him, because Andy then could see that he was on his own and he better look out for himself. And so he was probably very happy to cut a deal. Because he'd been already cut loose. So, you know, some of these people who do these criminal acts are not very bright in that way. You know, they may have got PhDs in economics and finance. I think, yeah, Ken Lay was economics, Jeff Skilling was, I think, finance. And, you know, but, and, you know, he's a consultant, and may have been basically selling his expertise. All that's to what it is. He simply didn't have the character to run a firm. He couldn't resist the temptation of looking the other way. All he wanted to hear was good news, and he challenged anybody who brought in bad news. You got to take the bad news with the good. Anyway, aiding and abetting. So there are many people who simply, in these corporate scandals, get caught up in the thing. And in Enron's case, you had some people, lawyers and accountants, who were saying, should we be doing this? They were challenging it. And then they'd be told, oh, well, Andy says it's okay, or Jeff says it's okay, or Ken says it's okay. And on that basis, they did it because they thought, well, these men are much more experienced and have maybe more education than I do, and therefore they got caught up in it. Aiding and abetting, though, it's the same sort of thing. If you drive the getaway car, you're going to be liable. and if you were actually cleaning up the mess, if you were cooking the books, or helping to cook the books, I guess is the thing, you then are aiding and abetting. Even though this was not something that you set out to do, it was something that you maybe even challenged, but if you participated in it, you were subject to being prosecuted. Like I said, many of these probably weren't prosecuted because the attorneys, the prosecutors know, the lawyers prosecuting them know what the score is. And on the other hand, some of them needed to be prosecuted in order to make the case against the chief defendants, and they were given much lower sentences usually. Like I said, if they had prosecuted Lee Fastow, which was Andy's wife, if they had prosecuted her, she probably might have gotten a year or two at best, at worst. You know, and that would have been all they would have gotten against her, because her involvement was not that major. It was just, she was involved, and she'd done some things she shouldn't have done. But now let's just go to another person. Of course, everybody knows that we had a whistleblower at Enron. Was she prosecuted? No. Did she know that there were lies being stated about the Enron's profits? Yes, she did. She sent a letter to Ken Lay saying she was afraid that it was going to be, that there was going to be an implosion, that it was all going to get, you know, it was all going to collapse at some point. And so that letter got leaked to the secretaries, and the secretaries started dumping the stocks that they owned, because everybody at Enron was buying Enron because it had grown so much. And there's this sad story of this one guy who was a lineman working with the electric lines, okay, and he had been investing some money for his pension fund, but he had not invested too much in Enron. And his other and fellow employees were kidding him about it, saying, "Oh, look at how much I made. Why don't you get smart and invest with us in Enron? Look at how we're growing." You know, and so he did, and he lost money with all the rest of them. So yeah, he did. He was doing what I would have advised any of my students to do. If you're in a situation like this where you're working with a company and you've got some money you want to invest, then you need to diversify that. That means you're not going to be investing in the firm. Although it's very lucrative, firms will oftentimes give you some sort of discount on stocks, or give you some extra stock if you buy an offering. You know, so they may try to get you to do that. If you do it, my advice is sell it later. Yeah, which is what Ken Lay did. Ken Lay complained that he had been investing in Enron all along. Yes, he'd been buying and selling Enron all along. Most of his stock came from Enron as part payment for his already huge salary. He was also getting stock as payment for his services. So I don't feel that he really is in that same situation. And his excuse of what he was doing was not a violation of securities law, not a violation of insider trading, was, well, I was just simply diversifying. Any good investor diversifies, you know. So if anybody tried to ever tell you that you had, when you sold the stock that had been given to you, that you had some inside information, you say, well, I didn't have the inside information. Even so, I was diversifying. Any smart investor would do that. And so, aiding and abetting. Prior to a 1994 case, auditing accountants were frequently charged with aiding and abetting in cases where management defrauded by cooking the books. And so in 1994, the Supreme Court assisted corporate management again. Accountant-client privilege. Many states have adopted by statute this privilege. The courts of these states, the accountant cannot be called to testify against the client. There is no federal accountant-client privilege. So, you know, certain states might provide a privilege. It's not necessarily one that's going to be recognized by federal courts in regard to federal laws. And so there's no federal accountant-client privilege. Some states have it. So if you're being prosecuted by a state, not likely. They're not the ones who you need to be watching for. if you're a criminal, as Holmes used to say, it's the criminal who really understands the law, because he's thinking about how he can avoid running afoul of the law. And if you're going to be cooking the books, you then need to think like the criminal. That is, you need to think, how can I avoid getting caught? And so you might need an attorney who doesn't mind the unethical practice of telling people how to commit a crime, and he himself would be then an aider and abettor. If he thought about it, he would know that. But he'll figure that you're not going to turn him in. And I guess maybe the two of you think you can beat the system. Anyway, that's that. There's no federal, so that's the case there. Crouch versus U.S., and I give the citation right there. Accountants' working papers. These are discoverable. Okay, so if you're being prosecuted, they can ask for the accountant's working papers. They can ask for the working papers of the in the corporation's accountants. They can ask for the working papers of the auditing accountants who are coming in to check them, like Arthur Anderson. They can ask for those papers. They can discover them, and it's a crime once the prosecution has begun. Once you know the prosecution has begun, you cannot destroy those papers. So this is one of the things that got Arthur Anderson into trouble, is that they even had an attorney who was telling people to do this. And of course, I don't know what happened to her, but she obviously should have lost her license. And she didn't do any favors to the people who were, then, and to the firm itself by advising them to do something which was clearly illegal. It's a crime to destroy them if a prosecution is imminent. Imminent means it's going to happen soon, once you know it. So you get a letter from the IRS and they tell you they're thinking about investigating and they're thinking about filing charges. Yeah, well, you know what they're looking for. And so don't be burning it. In some state courts, an accountant can claim a work product immunity. But again, that's not a federal rule, that's in the state court. Although accountants own their internal working papers, they owe clients a duty to transfer them upon request, and their clients have a right to review them upon reasonable notice. Who are the clients? Who are the people who have a right to the papers of the corporation? It should be the shareholders, right? Yeah. SOX, Section 102A1, Accountant Work Product. Auditing accountants must keep and maintain work papers for a period of 7 years from the end of the fiscal period for which they were prepared. That's quite some time, right? So you need to keep these. Anyone who willfully alters, destroys, or conceals documents in order to obstruct justice can now be sentenced to 20 years imprisonment. Now, some of these things sometimes get discovered even though there was an attempt to destroy it. You've got to go and destroy, oftentimes, your computer and its memory, and so you want to do with one of what Andy Castell had a very close friend of his who he'd hired to work with him in his office, and that guy went out and threw his, after pretty much destroying it, he threw his corporation into a junkyard. First he disabled it, tried to destroy whatever memory was there, but he wasn't taking any chances that somebody would figure out how to recover that information that's on there. And he just simply made it impossible by going out and destroying it. And basically nobody knows where it went to. He never disclosed where he threw it. And nobody knew. They were not able to get their hands on it. But if they can get a hold of your computer, there are lots of clever people who know how to extract information from these computers. Okay. Securities fraud statute of limitation. SOX Section 804 sets a 2-year filing limitations on security action from discovery of the securities fraud. So there is, it's not 2 years from when you did the act. It's 2 years from when it became public knowledge. When people began to know and could know about it. So 2 years from discovery. So this is similar to maybe what a lot of tort statutes have looked like in the past, in that they have a discovery statute. You do find sometimes groups, and I don't know, this is something that maybe the accountants or the corporate officers might want to use their influence to change, as did the medical doctors, whose statute of limitations does not have a discovery provision. You've got a fixed number of years to bring that suit. And it actually is a fairly long time, but it's not forever. Okay. Securities fraud statute of limitation, okay. And a 5-year limitation from the commission of the crime. Oh, whichever is earlier. Oh, I'm sorry. I guess they do have that, don't they? They already have it. They already had it when I prepared these slides, which is it. Now, that's what I got for you for today. Next week, on Monday, we'll be getting into matters of administrative law and matters of regulatory law. And so we need to talk about this. Now you might say, well, weren't we just talking about that? Well, this is kind of a bridge in that these securities law, in some sense, are a continuation of the tort law that we saw. And they have, you know, in terms of even Roman law, where agents became responsible, for, you know, masters became responsible for their servants and agents. There is a continuation there. And, you know, so you find that this was, a lot of this can have a lineage that rests in tort. And so, but it is now maybe considered to be largely regulatory. But think about it. A tort is something where you have a cause of action to recover money. Shareholders have a cause of action to recover money from a corporation, and even from officers and directors, if they can only pin the case on them, which is oftentimes very difficult. It's, you know, same as, you know, for the Pinto automobile, you know, Ford Motor Company got sued, and if they could have figured out who actually made the decision to go ahead with the building of those cars that were defective, a person could have brought one if there was ever any sort of like real trail leading to one person. If there had been enough evidence against, say, Lee Iacocca, who was the president of Ford at the time, he could have been prosecuted if he was the one who said, yes, go ahead and release it, even though it's got this defect in it. But I don't think they ever had that kind of proof against any particular person in the organization. But somebody had to prove that. So SOX Section 804 set the 2-year limitation for filing, and a 5-year limitation from the commission of the crime, whichever is earlier. There we go. And that was the toughening of the sentence. So before that, it was even easier. So no wonder people can commit white-collar crime. Otherwise, admirable even officers and directors. You know, I think that some of these people, in some ways, are admirable. They would be very good citizens, but they need sometimes to have laws that fence them in. They have maybe a lot more greed. And greed is a vice. Not everybody would be as greedy. Not everybody would do this, and some people wouldn't do that. So I don't think Sharon Watkins was wanting to do it, but she was protecting herself by selling her stock when she knew there was going to be maybe trouble with her stock. She did it, but prosecutors didn't prosecute her because they had so many other big fish too, and she had actually been instrumental in getting it disclosed, although she was an unintentional. She gave it to a secretary who was supposed to give it to her boss, who read it, which she wasn't supposed to do, and then told the other secretaries, and it went throughout the firm, and eventually somebody told the Wall Street Journal, and you know, it's all traceable to Sharon Watkins, so she got credit for being a whistleblower. She's an accidental whistleblower. In a way, it's fortunate for her she was, because if she had sold that stock and there was nothing coming out from her to other people that got credited to that, she had credit for that, I think that would have been the end. Anyway, that's it for now. I'll see you again on Monday. Thank you very much.